Good afternoon, everyone. We hope you all are keeping well. On behalf of the entire editorial board of RGNUL Financial and Mercantile Law Review, I would like to take this opportunity to welcome one and all to the expert panel discussion of the second RGNUL-SAM Conclave on practical aspects of information technology and data protection. My name is Harshit Kapoor and I am a junior editor at RFMLR and a second year student at RGNUL Punjab. I'll be the host for today's event. Mr. Prakhar Deep will be the moderator for the event. Prakhar sir is a senior associate at Shardul Amarchand Mangaldas Co and is an alumnus of RGNUL, batch of 2014. Thank you for joining us, sir. RFMLR is a biannual double-blind peer-reviewed law journal published by RGNUL. The journal is indexed on SCC Online and has been consistently ranked amongst the 10 most accessed law journals by SCC Online. The editorial board also collaborates with legal experts and undertakes various academic initiatives to promote study and research in the field of business and commercial laws. One such initiative was the first edition of RGNUL-SAM Conclave on arbitration in practice, which was held in the year 2021. The conclave aimed to create awareness and stir debate around often ignored practical aspects of arbitration. And now RFMLR is back with the second edition of RGNUL-SAM Conclave, which has been organized in collaboration with Shardul Amarchand Mangaldas Co. This conclave, like the earlier one, has been divided into two parts, namely the paper presentation session and the expert panel discussion. The paper presentation session was conducted on 7th of May, and it turned out to be a very fruitful and intellectually stimulating event. Now, pursuant to the conclusion of this expert panel discussion today, we would be announcing the results of the paper presentation session that was conducted on 7th of May. The authors of the top entry will be rewarded with internships at SAM & Co. and a cash prize of rupees 10,000. We have with us Registrar Sir, Professor Dr. Anand Pawar, who is also the faculty editor of RFMLR. I would request you, sir, to say a few words before we begin the event.
Thank you, Harsh. Thank you. On behalf of Rajiv Gandhi National University of Law and on behalf of the Vice Chancellor who could not join because of other engagement, I welcome all the guests who took this for sharing their time and their valuable time on this important aspect of information technology, litigation, and data protection. On behalf of the university, I would like to say that the RFMLR, much of the contribution is of the students. They were working very hard and we were only providing them or facilitating them rather, and most of the work and most of their initiative were appreciated not only by the institutions but other part of the academicians and practitioners. So in this today's session, I'm thankful to Mr. Tejas Karya, partner and arbitration head, Shardul Amarchand Mangaldas, Mr. Gohar Mirza, partner Amarchand Mangaldas, Ms. Mishika Goyal, Director Legal Compliance and Privacy at PAU India. I have just came to know that she will join at that point of time. And Dr. Shobhajit Basu, Associate Professor of Information Technology Law at University of Leeds. And our own alumnus, Mr. Prakhar Deep, who always helped the institution and the students also. And we look forward to having more frequent session in reference to RGNUL-SAM Conclave, not only in reference to having these online interactions, but on university sides, we invite you and we welcome you all that whenever you get the time, we can have offline sessions also at the university so that the contribution which you are doing in terms of providing them practical information and knowledge to these budding lawyers can further be extended to all our students. With this, I welcome all the guests, and without taking much time, once again, I welcome all the guests and the participants from the university side. Thank you.
Thank you so much, sir. Before starting, I would like to request all the attendees to direct any questions only to the panelists designated as Q&A. And I would just humbly request you to refrain from directly sending questions to our esteemed panelist or moderator. Prakhar sir, the floor is all yours. Thank you.
Thank you very much, Harshit. Thank you, Dr. Anand Pawar, for the warm welcome. And I welcome all of you to the second edition of the SAM RGNUL Conclave 2022. Last year, we had a very engaging and brainstorming session where we discussed the aspects of arbitration law and their practical implications. This year, we have another topic, and this topic is more important in 2022 than anything else, which is information technology laws. Since pandemic, as we understand that the way we rely on technology has increased, we started with the e-commerce, then it was e-learning, and today is the age of e-justice. So starting the first topic, which is something which we are yet to see in full-fledged, uh, working in India, is concept of online dispute resolution. Now, online dispute resolution, as you see, it's a method of ADR, but it's completely virtual and it is yet to be implemented completely. And we want to witness something which will really give her access to justice in a very simplified and easy manner. So my first question is to Mr. Tejas Karya, that since you have been handling for last almost 2 years all the hearings in many cases virtually, what do you think are the pros and cons of an ODR? And did you face any kind of difficulty or the benefits of a virtual hearing?
Thanks, Prakhar, and it's always a pleasure to be part of the joint conclave between RGNLU and SAM. We have great relationship, and we want to make it more stronger as we go along. Coming to the concept of ODR, as we have seen in last 2 years, and more particularly in all forms of dispute resolution, we are able to survive only because of the technology. Before pandemic, we always had this technology. It's just that we were not familiar in using that technology as we should have been. Of course, there were platforms which we could easily adopt when the lockdown was enforced. And of course, it took some time, but everybody got adjusted because ultimately we need to see the best available option to continue with our dispute resolution mechanism. An online dispute resolution mechanism gives an advantages which are unparalleled to any other mechanism, because what you are doing here is saving time and cost. Is the basic grievance where we talk to any of the stakeholders in the dispute resolution process are the parties who are involved and who have to spend for resolving these disputes. Now, saving time and cost goes a long way because ultimately what parties want is a quicker, faster dispute resolution at the minimum cost they need to spend for resolving the dispute. Now, the clear advantages of ADR is that we have to see that you don't have to travel for physical meetings or physical hearings. So that saves time and cost both. You have availability of the best resources who can be available across jurisdictions. So you don't have to worry about getting the experts for resolving the dispute. And you can also handle multiple dispute resolutions on a given day. So those are the clear advantages of ODR. But we also have to see that no system is foolproof. So when we talk about online dispute resolution, there are certain drawbacks to that, and we have heard a lot in last 2 years, especially because some people adopted it very easily and some people found it challenging to completely shift to the online dispute resolution mechanisms. And some of the challenges is that especially in the trials which we have to conduct, you are not in front of the witness, so you cannot judge their body language fully, or you are not able to have the control over your witness. There are also possibilities of your witness being tutored or because of multiple screens, availability of multiple screens in front of a person which is not visible to the other side, because you are only seeing the front part of the screen and not able to judge what is there in around the room. Of course, there are answers to that, is that you can have 360-degree camera, or you can have somebody present who can vouch for any kind of presence or of person or screen. But the feel of having in-person meeting or in-person cross-examination is not there in ODR. If you talk about mediation, mediation also has an interpersonal skill where the mediator finds the solution between the parties after talking to the parties in person. Of course, we have done a number of hearings of arbitration and mediation virtually, and there were no problems as such, but you don't get the same feel as you get in-person feeling. But personally speaking, I would always prefer a virtual mode as compared to physical mode, because we are able to achieve at least 90 to 95% efficacy, if not 100%, in virtual. But at the same time, the benefit we get of virtual hearing or the online dispute resolution is far more than the disadvantages which we see in this type of system. So I would personally prefer wherever possible, and if the both parties agree and the arbitrator or a mediator agree for virtual hearing, then I would always prefer that to have the ODR rather than the physical mode of dispute resolution. Thank you.
Thank you so much. So my next question is to Mr. Mirza. In 2021, Niti Aayog had prepared a 200-page report on its plan to implement online dispute resolution system in India. So the report contained why we need ODR and how the judiciary and the laws have to be future amended to adapt the situation, because what we see is, for example, recording of evidence, and there are certain situations where you need physical presence, and the Niti Aayog has suggested that in order to cater the large number of litigation and cases which will come along in future, we need to adopt a ODR system in parallel to the physical infrastructure in court that we have. So do you think that this can, in terms of Indian dispute scenario, can ODR become a permanent feature in the Indian judicial system in near future?
Thanks, Prakhar, for the question. And I am also very happy to be participating in this conclave, which we usually do with RGNUL. To your question, as Tejas was pointing out, see, ODR is the future, no doubt. But of course, as Niti Aayog is suggesting in the proposal that there has to be availability of an alternate always. And we have seen in the past few months or few years, past 2-3 years, that we have been using hybrid mechanism as well. We cannot rule out the possibility of a physical system available in terms of dispute resolution, because we have to also be awake to the concept of courts being in remote areas where internet has still not reached, or maybe the basic infrastructure of electricity or availability of VC rooms. So we cannot absolutely move away from the traditional way of dispute resolution. But yes, ODR is the future. It has its own pros and cons. Pros are more and cons are less. But when people talk about the fact that one has to reach a person in a village and make it available to them, I think the government and people, everybody has a role to play, and people should actually develop these skills into people so that they can approach courts faster than the traditional way of reaching for their dispute resolution. For example, if we are saying that, if we are advocating that the traditional way is the way forward and ODR cannot reach a remote location, we should actually work on infrastructure so that ODR reaches a particular location. So Niti Aayog is coming up with these hybrid solutions which actually are helpful. Prakhar and I am aware that we have recently done, and as Tejas was pointing out correctly, that there are certain issues when we cross-examine a witness and you need to know the credibility of a witness. And we recently had an example of asking for a hybrid hearing for a cross-examination in one of our matters. So we know that these interpersonal skills are actually available only when you are in the traditional system. But yes, ODR can be used in the future. It will not rule out the traditional system, but yes, this is the future. If the question is, it is the future? Yes, it is the future, according to me.
Thank you so much. Again, I'll move my question to Mr. Tejas. Now, what we have seen is that today, the way technology it is that, as a consumer, the access to services is primarily based on technology. Today, you need an app for everything, right? From net banking to ordering food to any kind of services, you need an app. Now, all these services which we get are through some specialized agencies. Some of them are intermediaries, some of them are IT companies, and it's like a collaboration of many people. The services we get in the end. However, when it comes to disputes, suppose today if there is a consumer dispute, what we have seen is that there are multiple parties which are arrayed in these disputes, and this leads to this sometimes lead to multiple litigations. So do you think that industry specific ODR mechanism should be promoted? For instance, if there is a dispute related to e-commerce, or dispute related to payments, or dispute related to any social media, so do you think that industry specific ODR platform should be promoted by the government to ease out and have specific kind of dispute by a specialized agency or a platform?
Thanks. Yes, the answer is yes, because we have seen that in last decade, we have heavily relying on the technology for every aspect of life. We are using technology for e-commerce, for payment. Everything is digitized. There is also a concern with regard to storage of data and processing of data. So when we talk about e-commerce and consumer related issues, we have now new Consumer Protection Act, which extensively deals with the rights of the consumers. And it also has e-commerce rules, which has been formulated under the Consumer Protection Act. And we have seen that there is a considerable progress in terms of the law, in terms of implementing and protecting the rights of the consumers. But the mechanism to resolve dispute requires a lot of changes. And as you know, we have not digitized, or we have not converted the dispute resolution mechanism to either virtual or online mode. The reason is that these disputes are large in volume. The amount in dispute may not be significant, but the rights of the consumer nonetheless have to be protected fully. And if we convert that process into a completely digitized online virtual system, that would really help to expedite and protect the rights of the consumers. How we can do it is, as you rightly pointed out, to do a sector-specific online dispute resolution platforms. And we have some of them already in place. The only thing we need to have is more and more availability of people to adjudicate these disputes, have trained lawyers who can file the claims online and have this decided in a specific timeline. We need to also ensure that we have the platforms where you can file all your claims. It has the processes inbuilt into those platforms, and the decision can also be made online. Because in this kind of dispute, there is it is not required to have a lengthy trial or proof of evidence. It's only about the services, deficiency in service or defect in goods. Now, when you're talking about defect in goods, those facts are easy to prove, or deficiency in service also can be decided in a very fast way. We have the consumer forums in India. You have the commission and national commission also. But we need to ensure that even today, the filing in these forums happens in a physical mode. So if we have to convert this entire system into online dispute resolution mechanism, we need large infrastructure in terms of the platforms, in terms of training, and also in terms of implementation of this entire ecosystem, where we can reduce the dependency on the physical filing, physical hearing, and adjudication by way of in-person mode. We need to move towards a complete virtual dispute resolution mechanism, where ultimately what you are doing, you are reducing the time and the involvement of the physical infrastructure by converting everything into online. So once we have sector specific dispute resolution platforms, we can tweak it to the as per the requirement of that particular sector. For example, insurance, healthcare, and in terms of electronic goods or electronic commerce, where you are having a FMCG, fast moving consumer goods items which are available, those disputes are petty disputes. You can resolve it very easily. But when it comes to the larger issues in terms of negligence in service, in terms of big items which are defective, you need to prove that there is a manufacturing defect or there is a defect which has been caused by the consumer itself. So those are the dispute which may require certain more time and effort, but we can have mechanism which is suited for every kind of dispute and every kind of sector within the consumer related dispute. So I completely agree. That's the future we have to look forward to and try to build this kind of systems where we can literally protect the rights of the consumer in the online world. Thanks.
So my next question is to Dr. Basu. Now, the judicial system in most of the countries is the prerogative of the government. Now we have the courts, we have the tribunals. Do you think that because of increase in terms of cases and in terms of demand and because of limitations by the government, do you think a private court or a mechanism where we have private dispute resolution forums which are uh, prepared, which are based on industry collaborations, do you think that is something which is a need of an hour? For example, in India there is a private dispute resolution called Justicens. It has handled around 8,000 cases in last 4 years. And do you think that this is something which is required at this stage to cater the needs of the people at large?
Yeah, thank you for your question and thank you for your invitation. I don't know much about what has been happening in terms of ODR in India, but I can give you two examples in terms of ODR. One followed by eBay, and the other one followed by Amazon. So in Amazon and eBay, if you have got consumer disputes, you go to the system of ODR, which is a lot cheaper, lot faster to redress the dispute. And I completely agree that our justice system is known to be very slow, very expensive, particularly in India, and small causes courts are not very effective. I used to practice in India in a different life. I did a few years, and I had a very bad experience of consumer courts, dealing cases in consumer courts. On the other hand, in UK, we have got small causes courts which are efficient, but they are slow. So Amazon and eBay's alternative dispute mechanism, where Amazon appoints an arbitrator, an independent arbitrator, to solve the dispute between the seller and the buyer, is much more efficient, is cost effective. The laws are quite laid down. It follows the rules of where the buyer is located based on European law and jurisdiction. And it has been working quite efficiently for past 15, 16 years. And through this process, we have seen lesser and lesser, at least what the previous speaker was talking about, the petty disputes were resolved much quickly, much faster, and to the satisfaction of both the parties. Thank you.
There is another follow-up question. Now, this question relates to more in terms of your area of practice and your area of study, which is concerns regarding the data storage and its interrelation with the privacy concern. So recently in the news, few days back, most of the VPN service providers in India were, directed by CERT, which is Computer Emergency Response Team, to share the user data. And all these VPN services said that our whole business works on the, not disclosing the identity of our user, and we cannot provide you data of these users. And the government said that this is in order to ensure that there is no cyber crime. And we are not asking for this data by the large companies you are providing to our corporates. It's only for the individual users. Now, what do you think in terms of the global trend that, when a law enforcement agency, requests such kind of information from a company or from such kind of technology where the business is based on the user confidentiality? What are your concerns, and what do you think the global trend has been so far in these kind of situations?
Thank you for a good question. I'm glad you asked me this question. So it's going to be about 22 years now that I'm now teaching cyber law since my PhD days in Liverpool. And in this 22 years, for at least quarter of a decade, most governments were slipping, thinking that these tech giants will work in favor of the users, in favor of the government. And then suddenly everybody has woken up, realizing that these tech giants are monopolizing the market, they're monopolizing how data is shared, accessed, processed, and everything. Now, if I start by saying, so in India, this whole debate has started with Justice Chandrachud's judgment on the famous privacy judgment, which I also teach here in Leeds, with the right to privacy. And that led to obviously the Sri Krishna Commission, which followed the draft bill where I was involved with the National Law School, Bangalore. We responded to the consultation, which followed by the JPC report in December. And this JPC report actually created the biggest damage, because the JPC report focused so much on data sovereignty rather than data privacy. Now, if you look at the entire European situation, data protection is a very European project. It started in Europe. The concept was framed because during the Second World War, the Stasi and the Nazis, they used to collect information. Nobody ever bothered whether the information was accurate. So after the Second World War, the thought was always there that we need to have a privacy protection legislation, which is pan-European. And then obviously from 80s onwards, they thought about having a data protection legislation. Coming into 95, the Data Protection Act. Now we have the GDPR. Now, GDPR, the concept of GDPR data protection is obviously you protect the data of the individual, but not just the individual against the private entity, but also against the state. It's a right against the state. And that is the principle which in data protection, which normally people overlook, which India has definitely overlooked. So when Indian government asks for data from the VPN, encrypted data from the VPN about the individual, it obviously is creeping into the domain where you are interfering with the individual's right to privacy. The problem here is, first, if you look at India doesn't have a data protection law at the moment, the IT rules are quite arbitrary. And then you have the exceptions. Every data protection rule has exceptions. And exceptions, if you look at UK data protection law or GDPR, the exceptions allows you to share data when it comes to national security or in a situation of pandemic. Now, none of the Western countries would ask a company, a VPN company or WhatsApp to share personal data, for the reason being that there are other stronger right to privacy legislation in place enshrined in the European Charter, which protects. Okay. When it comes to India, the problem is there is no such protection available. And the Joint Parliamentary Committee's recommendation has been very much focused on protecting the state's right, power given to the central government. So on the one side, although there should not be a request like that, unfortunately for national security purpose, if you see it says you can be asked to share data when it comes to national security, friend relationship with members, other nations, data can be asked to be shared. The problem is there is no legal framework, or Supreme Court hasn't been looking into this in detail to say you cannot do it. Can similar something like that can happen in UK or in Europe? No, it won't happen. But there is a corollary. When it comes to national security, like now in Russia and Ukraine war, the Digital Services Act, which European Union has just introduced, has a provision which allows that in situation of emergency, the state can interfere. The state can come in action to ask for data. But the legislation at the moment is very much focused on restricting misinformation and disinformation. Thank you.
Thank you so much. There is just a bit of a follow-up question on this, that following from what the government and the CERT has stated, that since what their case is that India now is facing a situation where there are a lot of fake accounts. Now, in order to tackle this, a lot of users are using these fake accounts through VPN services, and a private contract between an individual and a VPN service is overridden by the contract, bigger social contract that the government has for the people. And that is a reason that they are asking that only for the individual who are using it for their private work, we want the data, but not for any corporate. So if a corporate uses a VPN for their, maybe for important meetings and all, they don't want any data. So do you think that this is something which, in terms of, I mean, globally as well, because we have seen that, the way social media and the technology is being used. So do you think that there is the change is required, or the privacy laws in Europe, as you told about the, GDPR regulations, do you think that they are sufficient enough to tackle these kind of situations in other countries as well? Not taking the Indian example. Now, suppose a similar thing comes in UK, where suppose there is a government says that, there's a lot of hate crimes, racist crimes being done by trolls and, fake accounts. Do you think that then the government is right in asking for such data in context, in this context?
Look, we cannot deny that there is a problem in social media, and I'm very much in favor of regulating big techs. I've written about it. I've given lectures on it, but there is a method of doing it. Okay, you do not need to have access to data for the government to actually stop these things from happening. In UK, what we are doing at the moment, we are enacting a legislation called Online Safety Bill. The Online Safety Bill is creating a duty of care, making these big techs, the social media companies, responsible for the content that gets uploaded or the content that gets shared. And that is a much better way of dealing with situation like this than asking for for a VPN company or a social media company to give access to the very technology which keeps individuals safe. One thing you have to remember, and this is the fight Apple had with Federal Trade Commission in US and FBI, that once you give access, the backdoor access to the technology, one piece of technology, then the whole thing unravels. So you will not be able to protect the privacy of individuals, innocent individuals. It is not the perpetrator for whom we should frame the law. We should also frame the law thinking that there are a number of innocent individuals involved here. And if you look at the facility, the VPNs, and a platform like WhatsApp or Telegram provides, it allows people right to freedom of speech and expression. I'm not saying that the mode has not been used in a manner which is criminal. Okay, but you're all lawyers. If someone uses the bread knife to commit a murder, do you convict the individual who invented bread knife? Or do you find a way to ensure that the bread knife doesn't get used for the purpose of committing the murder? So the question here, the technology, there is nothing wrong with the technology. The technology can be used in the good and the bad way. Nuclear fusion has been used in the most destructive manner, but entire nuclear medicine is an outcome of that entire nuclear research. So when I was doing my PhD in Liverpool, we used to download copyright infringement material, basically music, until the university sent us an email saying that, look, we know what you are doing. You know what you are doing. You are infringing the law. Stop doing it. Okay? Otherwise, we will stop your access to the internet. And we did listen. But the technology of file sharing, that basic technology, is why we are having this meeting today. That was the fundamental technology. So you cannot make the technology a victim. Technology is neutral. It's the use of it that has to be controlled and regulated.
Thank you so much. That was a very to the point and the great example that you had given. And that is something which we should look for. Now, coming to the last topic of discussion today, which we have the IT litigation lawyers with us. Now, the first question is to Mr. Karya. What in times today, what do you think are the main issues involved in terms of IT litigation in India? And where do you think what is the way forward to it?
Yes, IT litigation has been quite interesting over some past period, because what we have seen that everybody wants to protect their rights. And when they are using technology, they don't know where to go. So, because there is no dispute resolution mechanism for such kind of disputes. So, either they are following the civil disputes, which is the normal court method, because there is no contract, there cannot be an arbitration between the technology service provider and the user. So depending on the availability and the resources of the users, wherever the cause of action arises, they file a civil suit before the court. The other type of dispute is that they file a criminal complaint against somebody who has violated their rights, and also join the platform in those proceedings, either as a witness to provide the evidence, or as an accused also sometimes. And the third is constitutional remedies. Although we know that the constitutional remedies of writ is not available against private parties, but the way to circumvent is they seek relief involving the government or the Union of India or the state government, and then also join these platforms as the co-respondent in those petitions. Now, the outcome of all the three proceedings are quite different. But one thing is good is that we have Section 79 into our Information Technology Act, which basically gives immunity to the service providers who host the content on their platform, provided certain conditions are met. And those conditions are also provided under Section 79 and the rules made thereunder, which is intermediary guideline rules. Earlier, there was a set of rule in 2011. Recently, these rules have been updated in 2021, and that has been expanded in terms of the scope and ambit of these rules. So basically, intermediaries have to follow the due diligence, and so long as the due diligence has been followed in terms of the rules, they have not hosted or modified the content on their own. And once they receive the actual knowledge, either by way of a court order or by way of a government notification, that Section 79(3)(b) has been clarified by the Supreme Court in the case of Shreya Singhal, where the court said that because of billions of messages are posted every day on these platforms, it's impossible for these platforms to gain actual knowledge on their own, or depending on the complaint which they receive. So the only way the actual knowledge is given to these intermediaries by way of a court order and by way of a government notification under Section 69A. So once we get that, they have a limited period of time within which they have to take down the content. These intermediaries are content agnostic. They don't take sides of either of the user or the person who is affected by the impugned post or objectionable content. Their role is to play as a neutral intermediary and not participate in the dispute between the parties who are fighting over the content which is posted on their platform. There are some platforms which are end-to-end encrypted, and that has its own challenges. The government has also tried to introduce in the 2021 rules a concept of first originator, and which is called traceability, where the government wants to find out that who uploaded the message first, irrespective of the end-to-end encryption. What happens basically is that it breaks the end-to-end encryption, because to find the first originator who started the message, you have to store all the messages, or at least been able to see who sent the first message and what's the chain. In end-to-end encryption, the key is always with the sender and the recipient. So even the platform doesn't have the key to that message, and there is no access to that message. So that gives also a sense of privacy to the users who want to communicate in their private space without having any fear of anybody looking at their messages or surveillance by the state authorities. Of course, there are certain loopholes, and we keep hearing news about softwares being developed and try to uh, come and see the messages, but that those are also not breaking the system which these platforms have developed. It is by way of putting certain malware into the handset of the parties who are then vulnerable to this kind of snooping. But at the end, no technology is foolproof. Everybody is trying to make their technology secure. And these technologies are also trying to provide various services to improve and enhance the user experience. And by doing so, there are issues which arise. For example, they give now the payment related services. They use the UPI, which is the Unified Payment Interface, which provides bank-to-bank transfer on the basis of the UPI ID. And they have the regulated entity called NPCI, National Payments Corporation of India, which is an arm of Reserve Bank of India, which regulates this particular entity and the business, where they have the tripartite agreement between the NPCI, the platform, and the banks who provide these services. So there are disputes arising out of every kind of usage of the technology, and intermediaries are invariably involved in those disputes. And the courts have been very, very proactive in protecting the rights of the users, as well as not unnecessarily involve the intermediaries where there is no requirement to do so. Of course, intermediaries are liable to the court orders, to comply with the court orders, and they have been doing so in number of cases, and they have been also supporting the investigations and complying with the orders passed under the constitutional powers given to the courts as well. But there are some judgments which clarifies that the writ jurisdiction of the courts are not applicable to the private entities, including the intermediaries. We have also seen number of disputes with regard to the protection of intellectual property rights also being fought where the intermediaries are party. Again, intermediaries have very, very limited role to play in this kind of disputes, because it is the dispute between the rights holder and the person who has committed the infringement of those intellectual property rights. And so long as there is a proof or the court order, there are systems in place where either the infringing material is put on hold or is taken down pursuant to the court orders. So ultimately, it depends on the nature of disputes. There are various avenues where the parties have to have dispute resolution in information technology related disputes. And we have seen number of cases where the law is quite settled now in terms of the use of technology and how it is to be decided against the service providers, users, and the people who are violating various rights. And we have seen a number of cases for defamation, which is under the defamation law. And we also have to see that whether the Indian court has jurisdiction to pass orders which would extend outside the jurisdiction of Indian courts. And there are some cases which are pending where the courts have exercised jurisdiction to direct this platform, which are global platform operating in hundreds of countries virtually, to take down the content outside India. And that's a debatable issue which the courts will decide eventually, is that what's the power of the Indian court to direct taking down of the content outside the jurisdiction of India, although the content has been originated from India. And that is something is a very interesting issue, because there is always a concept of conflict of laws, committee of courts, and whether you can have the same standard of tort of defamation applicable to the world, where every country has their own laws, and they should restrict themselves to their jurisdiction rather than imposing their laws in other jurisdiction. So those are a lot of interesting issues which arise out of the IT litigation as we go along, and this is just the beginning. More and more disputes will arise when we have the act under Data Protection Act. Earlier, it was a personal data protection bill. Now, after, as Dr. Basu said, if after this joint parliamentary committee, they may convert that into the Data Protection Act rather than personal data protection. So the non-personal data can also be included in this act, and that's going to open, in my view, a big Pandora's box, because we will have to deal with not only personal data but non-personal data, and that would get regulated. So either we are going to follow the EU model, and how the technology is going to evolve, because every company is collecting personal data as well as non-personal data. So in that context, we will have to see that how the IT litigation which will unfold. And my personal view, the IT litigation is a big future. And if anybody wants to specialize, that's a great scope for students to understand these nuances of this law, and try to specialize in this field of information technology and litigation arising out of information technology laws. Thank you.
Thank you so much. So my last question is to Mr. Mirza. Uh, Tejas sir talked about the intermediaries and how they have been, complying with the court orders. But in terms of dealing with the law enforcement agencies, there's an anecdote I want to share. I briefly worked in a fintech firm, and it was an intermediary, and its only job was to, provide a platform where the payment is made. And one day there was a notice from the cyber cell of some state calling the managing director to be part of some investigation where a merchant had frauded a customer, and there was a complaint filed. So, and without thinking, the investigation officer had just directly, sent a notice to the managing director. And we have seen that, intermediaries, when it comes to the law enforcement agency, there are a lot of challenges that they face. So what, in your experience today, what are the challenges that intermediaries face when it comes to dealing with the law enforcement agencies before a step where court is involved?
Thanks for this question, Prakhar, and you gave a very good example as well. So what is happening is that our criminal procedure code is very good, and the law that is developing in the IT side is developing very fast. Every day we have new tech, we have new rules coming up, and there are various court orders that come up, and they keep developing that law. So the law enforcement agencies, whether it's a police agency or CBI or anybody, they are not able to, according to me, they're not able to fast pace themselves to match up to that speed. So if there is a court order or there is a summon issued, they will always treat it as a normal summon. They will not understand the difference, or they are not still equipped. Most of them, a lot of them are, but most of them are not equipped to even understand what is the ramification of sending a warrant or a summon to a person who's not even located in India. What they understand is there is a court order, we have been asked to produce something, and there has to be something that has to be taken from the company. But whether the company is the right entity or not, whether the person they're asking for is the right person under the act or the rules, those nuances are not being gone into. And every crime is being seen as if the intermediary has committed. It can't be like Dr. Basu was rightly pointing out that if a knife is used, if a butter knife is used to commit murder, you can't go and start acting against the butter knife. You have to understand who has committed the offense, what is the nature of the offense, how can you get that information in a more proper manner, and there has to be a collaboration. So according to me, the concept of collaboration has to be learned by all the agencies. Even the intermediaries also need to learn the concept of collaboration, and instead of going adversarial against any party who is only doing business, only providing a platform to you, you should understand how to develop a mechanism. If it is not possible, what are the possible alternatives available? If the alternatives are not available, then you go ahead, because ultimately, like Tejas pointed out, Section 79, the intermediary will enjoy its safe harbor till the time they are following the court order. But if it is technologically not possible, for example, if there used to be cases where the call logs used to come from some BSNL or any other company, and there was a murder case and they used to take out call log. Today, like for example, there are some intermediaries which are end-to-end encrypted, and they have a calling feature. They cannot maintain call logs. So see the difficulty from the perspective of a person who is sitting in a police station. He thinks that because a call can be made through one phone to one phone to another, there is a log. But unfortunately, there is no log. If you make a Skype call to me, or maybe you make a Zoom call to me, if you are not recording it properly, or you're not deliberately recording it, there will be no call records, or there will be no video recording of it. So the officer sitting in a police station is not understanding that. They are only there to implement an order passed by either a higher up, or they want to expedite the investigation. But my suggestion or my view always has been that whenever there is a requirement of any collaboration, it has to be mutual, and it has to be in order to provide assistance to the law enforcement agencies, rather than going after a person who is not even aware of what actually happened. They will help you if they can, but if they can't, they will not be able to help. We have to understand all that. So I think that is where we are moving slowly. We are seeing a changing trend in the demands, or the notices, or the requests that are coming from the LE agencies. They are getting equipped with the technology. They are now, like Tejas was pointing out, that when a defamation suit is instituted in a court and a takedown order is passed, a URL is to be provided. Now they have slowly understood that yes, there is a concept of URL. You can't just go and just say click down some post, because there will be lakhs and crores of posts a day. So at least that concept of URL has come in. So now today, if somebody is demanding takedown of something, they are at least sending me a URL, or an intermediary a URL. So that is how we are slowly progressing. But since there is a difference in the pace, because technology will advance and will go at the fastest of pace, the agencies also need to pace to increase their pace to match up to the requirement that will actually help resolving all kind of problems that we are facing. So I think that's my suggestion, that collaboration is what we should look for, and rather than being adversarial to any intermediary, no names taken, but any intermediary.
Thank you so much. That was a
Can
that
I
was a
say
great.
can I say something? Just
Sure.
to agree with my two previous learner speakers. I agree with both of them. From the very beginning, when it comes to regulation of cyberspace, one of the biggest problem has always been not the law itself, but the enforcement of the law. And that has still remains the biggest problem. And a major reason for that is we never understood how the technology works before we try to create the legislation. That has been happening in the Western democracies. Okay, without understanding how the technology functions, the legislations were created. That's one problem. The second problem is when it comes to regulation of content, we have to also think about it's about regulation of behavior. You are not just regulating the technology, you are regulating the content that the users produce. So unless we can make the people aware what is acceptable and what is unacceptable, there will not be any change. And this is why in GDPR, we have got privacy by design and privacy by default. That is one of the steps. If you look at the new proposed data protection bill, which India has proposed, India has included regulation of social media in that data protection bill, which I find it a little bit disturbing in the sense, how would you intend to enforce that? That will be quite tricky. And when it comes to regulation of content, when it comes to particularly intermediary liability, it all started in 1991 in United States with the famous CompuServe case, and then the Communication Decency Act, which Trump wanted to get rid of. Intermediaries now use artificial intelligence to screen content, okay? And artificial intelligence you have to train them, and it suffers from biases. And this is where my problem is. So in one side, we want to protect national security. We want to make sure people's privacy are protected, government's interests are protected, and particularly for a country like India, where you have got vicious elements in it, you want to, and there's not much cohesion in the society. You want to make sure that for the peace of the society that there is some mechanism in place. What about freedom of speech and expression? That is also a right that gets overlooked. The moment the government starts interfering with the technology, you will have problems with rights. Some would say conflicting rights. And I always say it is not national security or privacy. It is not public order or freedom of speech and expression. It is both. And there has to be a way through which we can make sure that these intermediaries act respecting our law. Thank you. Sorry for the interjection.
That was a great take, and that was something which really summed up the entire discussion we had. And thank you so much, everyone. Thank you so much, Dr. Basu, Mr. Tejas Karia, and Gaur Mirza for a wonderful hot afternoon discussion today. And I thank you, all of you. Now, towards the end, I would really thank RGNUL and all the members of the RGNUL Financial Law Review, Mercantile Law Review, for giving this opportunity to discuss the topics which are really so important. And this year, in fact, we had a paper presentation also, and where we received numerous entries, and all the participants had written papers on all these topics, and we have received more than a great response from the students. Now I hand over the stage to the members of the university to declare the winners of the competition and the prizes. Thank you so much.
Thank you so much, sir. Finally, we have the results of the paper presentation session. It was indeed a tough competition between the participants. The final marks were computed on the basis of aggregate score of the manuscripts as well as the presentations given by the authors. So the final results are as follows. The first place we have Lisa Sanskrit and Pratham Arya. For the second position, we have Raj Shekhar and Aman Yuvraj Chaudhary. And for the third place, we have Gargi Vora. So we sincerely appreciate their efforts and the efforts of all the participants, and we wish you all the best for all your future endeavors. Last time, the editorial board selected a few entries which were published in a special issue. This time also, the editorial board intends to select and publish a few articles. We'll intimate the authors about the same in due course of time. And now I would like to thank Professor Dr. Anand Pawar for his aid and guidance in conducting this event, without which such events are not possible. So it is your constant support which enables us to organize such events. I would request you to give your concluding remarks.
Thank you. So on behalf of the university, we are thankful to the Shardul Amarchand Mangaldas. They have always guided our students wherever there is a possibility, be it as an intern or on the investment side. And Mr. Prakhardi, who is always a constant support to the RGNUL students. And for future also, we would like to have more interaction and more academic activities in collaboration with the Shardul Amarchand Mangaldas. And again, I repeat the same, that the next edition, if possible, will help on campus in offline mind, so that we'll be able to host you. And with this, once again, I'm thankful to Mr. Tejas Karia, Mr. Gohar Mirza, Ms. Mikita Goel. Unfortunately, she could not join, and Dr. Subhajit Vasu, and of course, Mr. Prakhardeep. Once again, we are thankful to you, and we wish that this concept will always be continued. Thank you all.
Thank you so much.
Thank
And
you.
just a last announcement, considering the great amount of hard work that the participants had put in the papers, the Shardul Amarchand would like to invite them and give them an internship in our IT litigation team. And I would request the organizers to forward us the names of the winners, and we can then take ahead with that. Thank you so much, everyone.
Sure, sir. Thank you so much. And I'm grateful to Dr. Anand Pawar. Thank you so much, panelists. And I'm also thankful to all the esteemed attendees for this session. Thank you. Stay safe.
Thank you so much.
Thank you.
Thank
Thank
you.
you.
Thank you, everyone.